Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My beloved lecturer, Dr. Zahir, and my fellow friends. I know even there is no friends because this is. I would like to express my delightful, my grateful to Dr. Zahir for this opportunity to make a presentation by using video recording. So this is my apologies for my unplanned trip to, which is not unplanned trip but planned trip, but early planned trip to Umrah, to perform Umrah, which was taken about 2 weeks from 28th of November until 9th of December 2018. So because of that, I cannot present to you in class in front of our colleagues. So I would like to take this opportunity to present what is my individual presentation. So the topic of my presentation is about the role of ILO in maternity protection of female workers in Malaysia. So as we know, female domestic workers, especially in Malaysia, have always been related with the issues of limited access to protection and measures which to ensure safety of their pregnancies and birth, and as well as replacement of income while they are on maternity leave, and the right to return to their jobs. So in the Decent Work for Domestic Workers Convention 2011, under Article 14, Sub-Article 1, Paragraph 1, requires members of the convention to take appropriate measures to ensure domestic workers enjoy conditions not less favorable than those generally applicable to workers in respect of social security protection, including maternity benefits. So, by this convention, it shows that all members or all countries must take appropriate measures to give fairness and justice to every employees or workers without regarding whether he is in maternity issue or not. So this is a kind of social protection. So these measures are to be taken in accordance with national laws and regulation. So by this convention, we have to see that what is actually the protection that have been taken, that have been provided by Malaysia. What is the protection that have been provided by Malaysia? First of all, let us see under ILO itself, the International Labour Organization law, which is ILO, recognized the importance of maternity protection when in 1919, in its third convention, it mentions about the importance of maternity protection. And then in 1952, the second ILO Maternity Protection Convention was adopted, which is known as Convention number 103. And in 2000, a third convention was adopted, which is namely as Convention number 183. So nonetheless, Malaysia is known as a state member of ILO who never ratified any of the three conventions regarding this maternity protection. Why? Why Malaysia did not ratify this maternity convention, this protection of maternity employees? If we look into the domestic law of Malaysia, there is actually no special protection which is against the termination or dismissal of an employee on the grounds of pregnancy, except under Employment Act 1955. Under 55, which it provides that an employer, when an employer want to terminate the service of an employee who is on maternity leave, the employer actually commits an offence under the Employment Act. So as a result of this, it actually shows that the employer can terminate the workers, which is related to maternity. However, they can terminate, but although it is an offence under Employment Act, they are only subject to the payment of a fine. So this is the Employment Act. It is not very comprehensive to provide protection for the female workers regarding the maternity. Not suffice with that, we also have the IRA, Industrial Relations Act 1967, which IRA actually provides the statutory rights to workers not to be dismissed unjustly. Even it is not mentioned, even it does not mention about maternity. However, it mentions about workers cannot be dismissed unjustly, and this includes protecting them from dismissal on the account of pregnancy or maternity-related issues. So there are two two legislations in Malaysia, which actually have some few of protection to the female workers regarding the maternity leave. However, we can see that by not ratifying the Maternity Protection Convention under ILO, it actually shows that Malaysia did not want to commit in providing a better protection for them. So let's see. Under IRA 1967, Industrial Relations Act, Section 20, Subsection 1 mentions that where a workman, irrespective of whether he is a member of a trade union of workmen or otherwise, considers that he has been dismissed without just cause or excused by his employer, he can make representations in writing to the Director General to be reinstated in his former employment. So this is under IRA. It means that if you have been dismissed unjustly, you can make report to the Director General and you can bring this case to the Industrial Relations Court. Okay, there are actually on my research, there are actually 4 issues that have been found, which regarding the protection of maternity protection for the female workers. There are actually many issues. However, it is down to 4 main issues which I have been getting from the cases, from the domestic cases that have been happened in Malaysian court, and what the court decides to each of these cases. So the first is dismissal while pregnant. The second is dismissal from work due to medical complications associated with pregnancy. Third is dismissal to avoid paying out statutory maternity entitlements. And fourth is dismissal upon return from maternity leave. So these are 4 issues which I will elaborate by using cases in Malaysia. For example, first issue is dismissal while pregnant. There are many cases that the employer had dismissed its workers due to pregnancy itself. Merely to the pregnancy, the reason, so they dismiss while the workers have been pregnant, and the court decides that dismissal while pregnant without a justifiable cause is not a good dismissal and is not a valid dismissal. For example, in the case of Sri Seltra Sdn Bhd and Yap Kwai Hua. So in this case, the claimant alleged that she had been forced to resign in her advanced stage of pregnancy, while the employer argued that she had resigned as she could not handle the pressure of her job and was under stress. However, during the proceedings, the court found that the employer actually had forced her to resign without just cause or excuse, as the employer has sought to remove her as she had been due to to go on a maternity leave. So the court noted that the 3.5 month salary and benefits paid out to her, which she had not been entitled to, had been made to persuade her to resign or face a dismissal without receiving any benefits. So this is the case. So this is an unfair dismissal. Another cases in Aznalisa Yaakob and Malaysian Banking Berhad Maybank. The claimant, a probationer, was dismissed when she is 7 months pregnant on the employer's claim of poor performance. The employer claims that she had a poor performance. However, noting that the employer had neither warned nor counseled the claimant on her alleged incompetence. The industrial court held that the employer had not discharged its burden to show that the dismissal had been done because of the pure performance, because of with just cause or excuse. So the industrial court agreed with the claimant's assertion that she had been dismissed on the basis of her pregnancy and not for her poor performance. So this is the court decide. However, in another case, the court decides vice versa. For example, in the case of Beatrice, anak perempuan A.T. Fernandez and Sistem Penerbangan Malaysia, where in this case, the flight stewardess faced dismissal from employment when pregnant on the ground that the collective agreement, the employment agreement requires them to resign upon their pregnancy or face a summary dismissal by the employer. And some of these claims in respect of the collective agreement have actually been done because the stewardess, there are many cases of stewardess who have a child while on leave, or who had gone on extended sick leave to conceal the pregnancy, or who were dismissed after suffering a miscarriage. So this is actually one of the terms and conditions that have been put in the employment agreement in order to take care of the, because this is the requirement of the aviation industry, and the pregnancy cannot fly because it is dangerous to their child. So the court decides that in this case the collective agreement or the employment agreement is valid, and the employer has the right to dismiss its workers, its female workers, due to pregnancy, because that is agreement that have been agreed by the female workers. So the court, so there are actually many decisions by reciting these cases that, like I said before. So the industrial court actually has no stand or firm principle in this issue, whether dismissal regarding the pregnancy is unfair or fair, whether it is considered as an unfair dismissal or fair dismissal is actually, there is no firm decision by the court. The second issue is dismissal for absence from work due to medical complications associated with a pregnancy and birth. In the case of Kavita Krishnan and 18 Sneha, the claimant, a senior human resource and admin executive, was dismissed before she could go on her maternity leave on the employer's, because the employers claimed that he had breached the company rules and misuse of her position. However, the industrial court noted that the employer actually had been unhappy with her poor attendance due to complications with her pregnancy. So the employer refused to accept her medical certificate and proceeded to deduct her annual leave and salary. So because of this, the industrial court said that the employer did not dismiss her because of breach of company rules and misuse her position, but because of her poor attendance due to complication with her pregnancy. So this is actually the right of the female workers, because they are not asking for complication during their pregnancy. So this is kind of cases that the industrial court cannot give opinion, good justice to the female workers. The third issue is dismissal to avoid paying out statutory maternity entitlements. For example, in the case of Perunding Bella Sdn and Leong Wai Teng, the claimant had been alleged to be dismissed on the ground of incompetence 1 month before she had given birth. So the court regarded the employer's action as being inhuman and considered it to be a form of unfair labour practice. In the inference drawn by the industrial court, the court found out that the worker had been dismissed by the employer to avoid the giving maternity leave and paying out the maternity allowance. And the fourth issue is dismissal upon return from maternity leave. In the case of dynamic management Muslim Rahat and Yong Yu Swan, the claimant found that her duties had been reassigned to another colleague during her pregnancy when her department had been restructured. So she was then told to leave the company, which she refused to do so. So she was at an advanced stage, as she was at an advanced stage of her pregnancy. She then continued to work, but went on medical leave for a month. 1 week after returning to work, she delivered and went on maternity leave. She was denied a bonus while on maternity leave, and upon her return from maternity leave, she was given no work assignments, found her office in a mess. Her computer had been removed and the office cabinet had been locked. She was even removed from the company's organizational chart to show that there was no place for her in the company. So, in this case, she claimed constructive dismissal, and the industrial court finding was in favor of the claimant, which was upheld by the High Court on a judicial review of the decision. So this is a kind of unfair dismissal of the female workers, the four issues which related to the protection of the female workers regarding the maternity leave. So by these cases, we can summarize that there are actually inadequacy of remedies under the IRA, because the IRA does not provide a good protection but merely leave it to the court to decide. While because when women workers are not awarded reinstatement to their previous workplace, they are actually handicapped by their pregnancy or maternity. They are just giving birth. In that, they will not be able to get another job until the birth of their child have been safely done, or have been their confinement have been done for 100 days, 90 days. So they suffer from the financial loss of income, which is more severe at the time of pregnancy because they have no opportunity to find another job. So there is no reinstatement. In addition, women workers lost their seniority and service with their employer. So this is one of inadequacy under the IRA. So this is why we need ILO to come in. This is why we need Malaysia to ratify the ILO. Because under ILO itself, even under the international law, we can see that there are actually many maternity protection conventions that have been done. For example, like Maternity Protection Convention in 2000, which includes the entitlement to paid maternity leave and breastfeeding breaks, maternal and child health care, the prevention of exposure to workplace health and safety hazards, and so on. While in Malaysia, which did not ratify the ILO convention. So the protection is always referred to the domestic legislation and judiciary as the main source, like before in the industry. However, as statutory protection under Employment Act is limited, so the role of ILO is a critical aspect to be ratified in order to provide maternity protection in Malaysia. One problem from my analysis in this article is that the industrial court approach to pregnancy and maternity issues at the workplace has no firm decision. It is clear that the industrial court has to play a balancing role in respect of an employer's right to run his business and his contractual right and prerogative powers over his employees. On the one hand, they also actually responsible to protect the employee's economic interest in her job, because she actually undertake her reproductive duties, not just a mere absence from work. So in the conclusion, the analysis from this paper, we can see that there are actually many forms of adverse treatment for women workers in Malaysia in respect of dismissal and termination of employment, which related to pregnancy and maternity matters at the workplace. It is clear from the fact that Malaysia did not ratify any of the ILO conventions regarding the maternity protection, as well as lack of statutory protection against such dismissal, which by this non-ratification has to a large extent affected or resulted in these discriminatory practices, which have been highlighted in the cases that before. So, the industrial court, in deciding unjust dismissal claims by women workers in such cases, recognized that the dismissal or termination of employment of women workers on the ground of related to pregnancy or maternity are forms of unfair labor practice and are therefore categorized as unjust treatment. However, the decision can always be decided vice versa. For example, in the case of Beatrice and sistem penerbangan Malaysia just now, where the court held that the employment agreement is actually sufficient in order to dismiss the worker because of their pregnancy. This is kind of unfair treatment for the woman because of their reproductive duties. So there is a need for Malaysia to ratify the ILO Maternity Workers Convention in order to protect the interests of the female workers, which should be treated as no less favorable than the other employers. It is their nature of women to give birth, to be pregnant, while for male there are another nature for male. So this is kind of unfair if by just pregnancy or giving birth they have been discriminated. So in the conclusion, the ILO has to play its role in order to make Malaysia ratify this all of their maternity protection convention in order for us to uphold the right or the interests of the female workers in Malaysia, inshallah. So that's all from me. My apologies for any weaknesses, for any discrepancies in my presentation. So once again, I am very thankful to Doctor for giving me this opportunity to present in the recording video. I hope that this presentation is satisfying to you. And if there is anything, just tell me, or if you need me to present again in another video, I can do it, inshallah. Until we meet again, Doctor, thank you very much for your knowledge, for your teaching for this one semester. Hope we meet again next semester or for another semester. Thank you very much, and Assalamualaikum warahmatullahi wabarakatuh.